Contract terms. Chapter 6 consists of contract terms, warranties, disclaimers, and remedy limitations. I think remedy limitations have been covered in another recording. So I will stop sometime before the Omni case so that this discussion is isolated upon an introduction to the study of contract terms, an introduction to warranties, the creation of warranties, such as the warranty of title, express warranties, puffing and affirmations of fact came in to that discussion. Implied warranties of merchantability, implied warranty of fitness for a particular purpose, warranty disclaimers, and implied warranty disclaimers, remedy limitations. Skip the Razor vs. Hyundai motor up and go into privity. Warranty litigation, defenses, and warranty action. Cause of action for breach of warranty notice and privity. Now, privity and cause of action for breach of warranty and notice all fall under warranty litigation, defenses, and warranty actions. Now, for an introduction to the study of contract terms, once you have determined that the parties have formed an enforceable contract and that there are no applicable defenses, the question becomes, what has each of the parties agreed to do? To answer that question, we now begin our study of contract terms. This chapter is the first of 3 chapters that explain how to determine the terms of the contract. The contract terms determine the parties' rights and obligations. A thorough understanding of contract terms then enables the student to analyze performance by comparing what was promised to what was actually received. Contract terms can be expressed, stated by the parties, either orally or in writing, or implied, in fact, or by law. In addition, because Article 2 makes it relatively easy to form contracts and the parties may well not have negotiated each and every term in the contract, Article 2 contains many default terms, often referred to as gap fillers, that become part of the parties' agreement unless the parties expressly negate those terms. Warranties are some of the most important contract terms in sales contracts. So we begin our study of contract terms and warranties. Note that warranties can be expressed or implied. Subpart 2, let me actually pay attention at this point in time because this is actually important. Relevant chapter. Introduction to warranties. The subject of warranties is very complex. I have learned from past students that it is helpful to overview all of the material to be covered and then return to each topic separately. Therefore, what follows is a short synopsis to make it easier for you to grasp the technical nuances involved in understanding warranties, warranty disclaimers, and remedy limitations. First, we explore how warranties are created. Under appropriate circumstances, the warranty of title is automatically part of a sales contract. Express warranties arise because of affirmative acts or statements made by a seller of goods, unless it's a very complex person. Unless properly disclaimed, the implied warranty of merchantability arises when goods are sold by certain types of merchants, and the implied warranty of fitness for the particular purpose arises when specified conditions are met. Next, we focus on warranty disclaimers. Even though the code provides for all of the warranties described above, it also permits a seller to sell goods without warranties and to exclude or modify warranties. A contract clause that it modifies or excludes warranties is referred to as a warranty disclaimer. An effective warranty disclaimer deprives the buyer of a cause of action against the seller, and the goods would otherwise be warranted. Therefore, it is important to study how warranties can be disclaimed. Buyers normally do not like to buy goods without warranties. Therefore, many sellers avoid warranty disclaimers. Instead, these sellers take advantage of the code provisions that permit a seller to limit a buyer's remedies. In many cases, remedy limitations deprive the buyer of more redress than do warranty disclaimers. Accordingly, this chapter looks in depth at the remedy limitations. We next look at the warranty material from the perspective of a litigant and examine a cause of action for breach of warranty and the typical defenses raised in warranty actions. We also compare and contrast a warranty action to a product's liability suit. Finally, we briefly review the Federal Magnuson-Moss Warranty Act to see how it changes the UCC rules when a seller chooses to give a written warranty of a consumer product. Now that you have a thumbnail description of what Chapter 6 is all about, we focus on the details. As you study this material, remember that warranties are actually gap fillers, which together with other express contract terms and other implied terms, the code gap fillers, which we discuss in Chapter 8, determine the parties' contract rights and obligations, the code sections that create warranties as default terms and that govern warranty disclaimers and remedy limitations are listed in Figure 6.2. Now again, the sections of the code. 2-312 gives title, warranty of title. 2-401, void title. 2-402, voidable title. 2-403, good faith purchaser. Entrusting and value. Good faith purchaser is actually defined in 1-201 and value in 1-204. Section 2-313 discusses express warranty, which includes affirmation of fact or promise, basis of the bargain, puffing, sample, and model. 2-314 is where to find the merchant definition with respect to goods of that kind, fungible, and fit for the ordinary purpose. 2-315, fitness for particular purpose. 2-316, warranty disclaimer, conspicuous, as is, with all faults, etc. 2-317, accumulation of warranties. 2-318, third-party beneficiary. 2-719, remedy limitation, failure of essential purpose. There's an exercise that I'm skipping about warranties, how they're created, how they're disclaimed, and some issues. Creation of warranties. The first to discuss is the warranty of title in section 3.1. The warranty of title guarantees the buyer that the seller has the right to transfer goods and that the buyer is receiving good title. It automatically arises when there is a contract of sale. To understand claims based on the warranty, you must also understand the concept of void and voidable title and the concept of a chain of title. You may have already studied these concepts in your property class. Essentially, a person who has void title does not have title at all. A person with void title cannot transfer title to another person. A person who has voidable title does have title but may lose it. Nevertheless, a person who has voidable title has the power to transfer good title to another person who purchases in good faith and gives value. You're lucky I was a realtor and don't need to focus right now. But now I would like to focus because the rest of this applies final. To analyze a title problem, you may find it helpful to draw a chain of title to show how a title passed from one owner to another. Figure 6-3 is an example of a chain of title based on the following facts. Olivia owner was the owner of a diamond necklace. She sold the necklace to Betty, buyer who paid cash. So you see OO to BB, cash sale, warranty of title passes. Under section 2-403, a purchaser of goods acquires all title which his transferor had or had power to transfer. Here, Olivia was the legal owner of the diamond necklace with good title. Accordingly, after the sale, buyer is legal owner of the diamond necklace with good title. If Olivia sells the necklace to Betty in exchange for a check, Betty receives voidable title until the check clears. This means that if the check is dishonored, Olivia has the right to get the necklace back from Betty due to the lack of payment. If, however, Betty transfers the ownership of the necklace to a third party, Teresa third party, before Olivia finds out about the problem, the third party may be able to defeat Olivia's claim to the necklace. Figure 6-4 shows the new chain of title. So it's just a chain of events from OO giving voidable title to BB because the sale was not paid in cash but paid by check, and the warranty of title is voidable. And then the next event of a sale to Teresa third party, passing on the warranty of title. Does not say what type of title Teresa third party has or what payment method she used to pay Betty Buyer for the diamonds. If Olivia refuses to sell her necklace to Betty and Betty steals it, Betty does not acquire title to the necklace even though she has acquired possession. Even if Betty subsequently transfers the necklace to Teresa, Teresa cannot get title to the necklace. As illustrated in figure 6-5, there is no chain of title that runs from Olivia to Betty if Betty stole the necklace. The illustrated Betty's title is void. Accordingly, she cannot pass good title to a third party. So you can imagine how the chain of title is broken in the next figure. The last example illustrates the importance of the warranty of title. In each of the first two examples, Olivia owner transferred title to Betty Buyer. As part of the contract of sale, she gave a warranty of title to Betty. In each of the next two examples, when Betty Buyer transferred the diamond necklace to Teresa as part of the contract of sale, she gave a warranty of title to Teresa. In the last example, Betty breached that warranty. If Olivia pursues Teresa and gets her necklace back, Teresa will have recourse against Betty because of the warranty of title. There's two exercises I'm skipping. We're entering express warranties, section 3.2. The next figure illustrates the three ways express warranties are created by sellers. Sellers create express warranties by statements or actions that relate to the goods being sold. They are not required to warrant their products. No magic words are required to create an express warranty. To be an express warranty, however, the seller's representations must become part of the basis of the bargain. And that part is essential because they don't have to be the basis of the bargain, only part of it. This figure shows how sellers make express warranties. There is 1, 2, and 3. 1, the affirmation of fact or promise made by the seller to the buyer that relates to the goods being sold. 2, the description of the goods being sold. And 3, a sample or model of the goods being sold. All three of those contribute to part of the basis of the bargain. It is not enough to state that an express warranty arises. You must also know what the express warranty is. In each case, the express warranty is that the goods will conform to what the seller made part of the basis of the bargain. 6.6-7 is the next figure, what express warranties are made. So if there's an affirmation of fact or promise made by the seller to the buyer that relates to the goods being sold, the warranty that goods will conform to the affirmation of fact or promise is created. If the description of goods being sold is given, the warranty that arises is that goods will conform to the description. And if a sample or model of the goods being sold is the basis of the warranty, what is created is the warranty that goods will conform to the sample or model. One of the most difficult issues in express warranty analysis is deciding whether a seller has made an affirmation of fact or promise, or whether the statement was puffing. The seller's commendation or opinion referred to in section 2-3132. Puffing does not create an express warranty. And there is a table on page 97 that compares and contrasts affirmations of facts to puffing. Listing factors courts consider to determine if a seller's statement of an affirmation of fact or promise or mere puffing. For an affirmation of fact, for example, the seller's statement is plain and ambiguous. Where in puffing, the seller's statement is vague or ambiguous. Sellers being plain and unambiguous. For an affirmation of fact, the attribute or quality involved is something buyer could easily ascertain on its own. Where at puffing, the buyer could easily ascertain attribute or quality without seller's input. For an affirmation of fact, okay, the attribute or quality involved is not something that the buyer could easily ascertain on its own. Puffing is the opposite. For affirmations of fact, the seller is more of an expert with respect to the product than the buyer. In puffing, the buyer is sophisticated and knowledgeable about the product. In an affirmation of fact, factor that courts consider to classify seller's statement as puffing or affirmation of fact, it would be reasonable for the buyer to rely on the seller's statements. Where at puffing, the buyer relies on something other than the seller. For example, a buyer may hire a consultant to advise him with respect to the purchase. For affirmation of fact, in favor of affirmation of fact, nothing in the facts indicates that the seller should not be taken seriously. But in puffing, facts indicate the seller is not serious or is inflating claims. For an affirmation of fact, in support of an affirmation of fact, the seller says nothing to the buyer that would put the buyer on guard. Where at puffing, the seller warns the buyer not to rely on statements or make buyer's own investigation. In support of affirmation of fact, the price tends to support the buyer's claim. Where at puffing, the price tends to negate the buyer's claim. Specificity and details provided is one of the characteristics of an affirmation of fact, whereas a lack of specificity or detail when a seller is puffing. Statement emphasizing years of experience with a product made by the seller supports affirmation of fact. However, statements that the seller makes that reveal goods are experimental in nature would constitute puffing comparatively. Written in contract, anything written in contract supports an affirmation of fact, whereas if the same statement were contained in advertisement, it could be more indicative of puffing. And lastly, affirmations of fact being written versus in puffing oral. The next part of an express warranty analysis is to determine whether the affirmation, description, sample, or model became a part of the basis of the bargain. The code does not define basis of the bargain. However, the official comments of Section 2-313 and the scholarly literature suggests that the phrase was selected to negate a pre-code requirement that the buyer must prove reliance on the seller's statement. Official Comment 3 explains the difference between the reliance requirement and the code's basis of the bargain language. Affirmations of fact made by the seller about the goods during a bargain are regarded as part of the description of those goods, hence no particular reliance on such statements needs be shown. So that's from Official Comment 3 to expand on the basis of the bargain reliance requirement. Again, affirmations of fact made by the seller about the goods during a bargain are regarded as part of the description of those goods, hence no particular reliance on such statements need be shown. Any discussion of basis of bargain must consider Official Comment 7, which states the precise time when words of description or affirmation are made or examples are shown is not material. The sole question is whether the language, samples, or models are fairly to be regarded as part of the contract. Litigants in court sometimes have relied on this language to find that statement made by a seller after a contract is formed can nevertheless give rise to express warranties. Section 3.3, implied warranty of merchantability. Unless disclaimed, the implied warranty of merchantability arises in sales when the seller is a merchant with respect to goods of the kind being sold. Not every party who is a merchant under Section 2-104 is a merchant with respect to goods of that kind under Section 2-314. For example, if Samantha seller is in the business of selling cosmetics, and we've entered implied warranty of merchantability, arises in sales when the seller is a merchant with respect to the goods of the kind. I'm not going to go into anything besides that merchant is defined in Section 2-14. People who buy cosmetics from the merchant will receive an implied warranty of merchantability. If, however, that merchant sells furniture instead of cosmetics, such as chairs and tables, even though she may be a merchant. She's not a merchant with respect to the furniture because she does not regularly deal in furniture. Therefore, there is no implied warranty of merchantability with respect to any of Samantha's furniture sales. Merchantability is not fully defined in the code. Instead, sections 2-3142A through F state minimum characteristics goods must have to be merchantable. Official comment 6 to 2-314 emphasizes that subsection 2 does not purport to exhaust the meaning of merchantable, nor to negate any attributes of merchantability not mentioned in text of the statute. Perhaps the most common standard is that goods are fit for ordinary purposes for which goods of the type are used. Note that merchantable does not necessarily mean perfect, nor even perfectly safe. It has been suggested that by merchantable, the code means that goods will work. Skipping an exercise and heading into section 3.4, implied warranty of fitness for a particular purpose. The implied warranty of fitness for a particular purpose arises only when 1, the seller at the time of contracting was aware of the buyer's particular purpose for purchasing the goods, and 2, the seller knew the buyer was relying on the seller's skill or judgment in selecting suitable goods. The buyer did so rely, and that element's important. Official comment 2 to section 3-2-315 emphasizes the distinction between the ordinary purpose of goods covered by the implied warranty of merchantability and a buyer's particular purpose as follows. A particular purpose differs from the ordinary purpose for which the goods are used in that it envisages a specific use by the buyer which is peculiar to the nature of his business, whereas the ordinary purposes for goods which are used are those envisaged in the concept of merchantability and go to uses which are customarily made of the goods in question. For example, Sky Walker goes to a shoe store and selects a pair of shoes to wear. Unless disclaimed, the seller gives an implied warranty of merchantability. The shoes are warranted to be fit for the ordinary purpose for which the shoes are used. However, Sky consults with the shoe salesman and asks for advice with respect to a pair of shoes that he can use for light hiking in the Sierra. He has disclosed a particular purpose for the shoes. If the salesman then makes a recommendation, knowing that Sky is relying on his skill or judgment to help her pick appropriate shoes, there will be an implied warranty of fitness for a particular purpose, and the shoes will now be warranted to be suitable for Sky's use for light hiking in the Sierra. Skipping the next section for warranty disclaimers. The purpose of a warranty disclaimer is to negate the existence of a warranty. Depending on the type of warranty, the rules vary with respect to how the warranty is disclaimed. 4.1, warranty of title disclaimers. Disclaimers of the warranty of title are governed by section 2-312, the same section that governs how those warranties arise. Subsection 2 provides a warranty of title will be excluded or modified only by specific language or by circumstances which give the buyer reason to know that the person selling does not claim title in himself, or that he is purporting to sell only such right or title as he or a third person may have. There is little case law dealing with this section. However, the reported cases do suggest that courts are very strict in interpreting the disclaimer requirements. Indeed, a recent case held that the words "there are no warranties" did not suffice to disclaim the warranty of title. The court reasoned that most buyers would not anticipate the seller denying the right to pass good title to the goods being sold, so the buyers would not understand that language to extend a warranty of title. On the other hand, most legal commentators would agree that a buyer who purchased a Rolex watch in New York City alleys should be put on notice by those circumstances that the seller may not have the ability to transfer good title to the watch. Note that the phrase is "as is," which is effective to disclaim implied warranties, does not disclaim the warranty of title. 4.2, express warranty disclaimers. Express warranty disclaimers are governed by sections 2-3162(1). The basic concept behind an express warranty disclaimer is that the seller is not free to give a warranty with one hand and take it away with the other. At first glance, section 2-316 appears to be straightforward and easy to apply. It states that words that create an express warranty and words that tend to negate a warranty should be construed as consistent if possible. However, if such construction is not possible, the warranty prevails. In other words, if a seller gives an express warranty, he cannot take it away. In many cases, it is possible to construe words of warranty as consistent with words of disclaimer. See, for example, the sample warranty in Figure 6-9. Identify the words that create a warranty. Next, identify the words that negate the warranty. Explain how they are consistent. It's not very long. It's a warranty. Seller warrants that this shirt will not shrink and its color will not fade, except as expressly set forth herein. Seller makes no warranties express or implied, including without limitation the implied warranty of merchantability. Now, there's another figure 6. I paused. Section 2-3161's reference to the parole evidence rule causes interpretive difficulty with Section 2-3161. A common situation is where a salesman makes representations to a buyer before the buyer enters into a written sales document. The sales document contains an integration clause and a clause that disclaims all express warranties. This fact pattern is illustrated in a figure. Section 2-316 says the words that create a warranty here, the salesman's statements, and the words negating warranties here, the disclaimer in the sales document, must be construed as consistent if possible. However, there is no way to make an express warranty consistent with an explicit statement that says there are no express warranties. Section 2-3161 then provides that if the words of warranty cannot be construed as consistent, subject to the parole evidence rule, negation is inoperative. Accordingly, the key to whether an express warranty disclaimer contained in a written agreement will negate an oral express warranty made before the parties entered into the writing is whether a court can be persuaded to admit the evidence of the oral express warranty notwithstanding the parole evidence rule. The evidence is admitted and the trier of fact believes it, there will be words of warranty and words of disclaimer that cannot be construed as consistent, and the disclaimer, words of negation, is inoperative. If, however, the parole evidence analysis dictates that the evidence will not be admitted, all that remains is the disclaimer in the written agreement, and the warranty claim does not survive. I'm going to skip exercise 6-7, which is a read of Killian versus Burren Equipment Company, which begins on page 102 and ceases on page 104 and enters into section 5, remedy limitations. Although the code may appear to be somewhat tilted in favor of buyers of goods, particularly because the warranty and warranty disclaimer provisions, its attitude towards remedy limitations easily outweighs that apparent favoritism. Section 2-719 specifically validates the notion that a seller can limit its liability not by excluding its warranty liability, but by changing the remedy to which the buyer is entitled in the event of a breach. Section 2-7191 specifically references and validates two of the most common types of remedy limitations employed by sellers. 1, limiting a buyer's remedies to return of the goods and repayment of the price, and 2, limiting a buyer's remedies to repair and replacement of non-conforming goods or parts. The only limits on a seller's ability to limit remedies other than unconscionability are stated in sections 2-7191B and 2-7192. First, section 2-7191B provides that resort to a remedy is provided as optional unless the remedy is expressly agreed to be exclusive. Since the adoption of Article 2, most sellers have written their form sales contracts so that agreements provide that whatever remedy the seller provides is agreed to be the exclusive remedy. Second, section 2-7192 provides that where circumstances cause an exclusive or limited remedy to fail of its essential purpose, remedy may be held as provided in this act. A determination regarding failure of essential purpose cannot be made at the contract formation stage unless you will not know whether a remedy limitation served its purpose or not until the buyer seeks a remedy based on the contract's remedy limitation provision. Accordingly, when you first are analyzing contract and its terms, you will only be able to determine that the seller has included a remedy limitation provision and may or may not make the remedy exclusive. You will not, however, be able to determine whether the remedy limitation will be effective to restrict the buyer's remedies until you have completed your analysis of performance, which is the only stage when you will be able to determine whether the remedy limitation failed of its essential purpose. Official Comment 1 to Section 2-719 is frequently cited by courts and legal scholars as expressing the meaning of failure of essential purpose when it says, it is of the very essence of a sales contract that at least minimum adequate remedies be available. A typical example of a remedy limitation that fails of its essential purpose is when a seller's remedy limitation provides for the repair and replacement of defective parts, and after the buyer requests a repair, the seller refuses to do so or is unsuccessful after many attempts. The purpose of such a remedy limitation is to let the buyer receive a non-defective good. If the seller cannot achieve that result, the remedy limitation fails. The last part of Section 2-719 deals specifically with the limitation or exclusion of liability for consequential damages. The statute provides that such an exclusion is valid unless unconscionable, and further provides that the limitation of consequential damages for injury to the person in the case of consumer goods is prima facie unconscionable. As in Section 2-3163, there is no express statutory requirement that a remedy limitation be conspicuous. However, for policy reasons, some courts have imputed such a requirement. The relationship between Section 2-7192 and 2-7193 has been the subject of considerable litigation. The question raises, what a contract contains both, one, a remedy limitation, such as repair and replacement of defective parts, and two, a limitation of consequential damages. If it is determined that the first remedy limitation fails of the essential purpose, does the limitation on consequential damages also fail, or does Section 2-7193 require separate analysis of the validity of that provision? The Illinois Supreme Court reviewed the current state of the law on that issue in Razor v. Hyundai Motor America. Its discussion of the issue in that case follows, starting on page 105, ending on page 108, and shifts to subpart 6, warranty litigation, defenses, and warranty actions. Section 6.1 is the cause of action for a breach of warranty. The plaintiff's prima facie case in an action for breach of warranty is outlined in Figure 6-11. Possible defenses in an action for breach of warranty are outlined in Figure 6-12. I think this sets forth what would be good to include in a essay. So I read the Figure 6-11, plaintiff's prima facie case for breach of warranty, as a 6-part list, starting with 1, the existence of the warranty, and there's 4 different types. The A, contract of sale, warranty of title, covered in 2-312. Here's B, seller's affirmations, which creates an express warranty per 2-313. There's C, merchant with respect to goods of the kind sold goods, 2-314, and seller sold goods buyer had particular purpose, 2-315. That all is part of the analysis under the existence of a warranty. Next, there's goods sold were not as warranted. 3, injury and damages to plaintiff and his property were incurred. 4, they were approximately caused by a failure of goods to be warranted. And 5, there's a notice to seller in some jurisdictions. And 6, there's privity in some jurisdictions, which we'll go into. The defenses. So in contrast, the other side of the essay would involve defenses on the seller's part in a warranty action listed as 1-7 in Figure 6-12. So 1, Article 2 is not applicable to the transaction, therefore alleged warranties do not exist. 2, deny facts based on which plaintiff alleges existence to warranty. For example, puffing versus an affirmation of fact or representations not part of the basis of the bargain. 3rd, goods were sold with effective warranty disclaimer, therefore alleged warranties do not exist. 4, goods sold were as warranted, scope of warranty. 5, breaking chain of causation. 6, untimely or inadequate notice to the seller. And 7, lack of privity in some jurisdictions. As illustrated in figures 6-11 and 12, the basic issues we studied in connection with warranties relate directly to the context of warranty litigation. 3 additional topics arise in the context of litigation. However, these are the requirement of notice in some jurisdictions and the requirement that the buyer and seller be in privity of contract and the statute of limitations. Section 6.2 sets forth notice. Article 2 requires a buyer to give notice to a seller in at least 4 circumstances involving breach. Section 2-607(3) requires notice of breach when a tender has been accepted. Section 2-6075 requires notice of litigation when the buyer is sued for breach of warranty. Section 2-602 requires notice when the buyer rejects goods, and Section 2-6082 requires buyer to notify seller by revocation of acceptance. Most courts have held that notice of breach is too late if given for the first time in the complaint. Because warranty litigation arises in connection with goods that a buyer has accepted, litigants must satisfy the notice requirement in Section 2-6073A, which requires a buyer to notify the seller of breach within a reasonable time after he discovers or should have discovered any breach. The penalty for late notification is that the buyer is barred from any remedy. Litigators suggest that the notice be detailed and a copy be attached to the complaint as an exhibit so that the plaintiff's case is set forth in detail. However, the code requires that the content of the notification need merely be sufficient to let the seller know that the transaction is troublesome and must be watched, per official comment 4 to Section 2-607. The last section I'm going to cover right now before the Omni case is privity, Section 6.3, because each of the warranty sections refers to contracts for sale or sellers in many jurisdictions. As plaintiff must be in privity of contract with the warrantor to recover. In general, privity of contract is of 2 types: vertical privity, see figure 613, and horizontal privity, shown in figures 614 and 15. So in vertical privity, there's the manufacturer, which flows to the distributor, which flows to the retail seller, which flows to the buyer. In horizontal privity, there's buyer's household. Buyer to the right goes to member of household, which goes to guest, which goes to trespasser, which goes to bystander. Figure 6-17, horizontal privity, buyer's business, which is buyer, goes right towards employee, which goes right towards business invitee, which goes right towards trespasser, which goes right to bystander. The UCC is silent with respect to vertical privity. Official comment 3 to Section 2-318 states that such issues are left to individual state law. Section 2-318 addresses horizontal privity, but instead of taking one approach, the drafters offered 3 alternatives. The first alternative, alternative A, is the most restrictive, and the third, alternative C, is the most liberal.